Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright.
Hello, everyone, and welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas.
And I'm Jamie Cudlitz. Welcome to our second episode, everybody. Today, we're going to cover a case about whether or not a school board had just cause to terminate a teacher's contract. This is a good one, everybody, and it really illustrates how dangerous sarcasm can be in the classroom.
No.
Yes, Chris. And I detected a little bit of sarcasm there.
So the kids are alright. So the kids are alright.
Great. Jamie, do you want to start us off with a bell ringer?
Sure. So I just came across this case recently. It came out of coastal North Carolina. I promise you there was nothing intentional about the fact that last week's case came out of coastal North Carolina, and one of this week's bell ringers also came out of North Carolina.
We're 2 for 2.
Yeah, I know. There's a lot going on in North Carolina.
Well, I'm in Florida. I get it.
So this case, it's really interesting because we know how influential athletics can be in schools, right? And this situation, I don't think it's worked its way into the court system yet, but this situation has to do with a school principal and a guidance counselor, I believe, who were suspended at the end of last school year for changing student athletes' grades for the purposes of keeping them eligible.
Oh, no. That's a bad look.
Apparently, the board thought so too. The interesting thing here is the former principal has referenced a state statute that indicates the duties and the responsibilities of a principal. And the provision in the statute said that the powers and duties of a principal is first and foremost to grade and classify pupils. Okay? And within that provision, it says the principal shall consider the pupil's classroom work grades, scores on tests, and the best educational interests of the pupil. Now, the interesting thing is to grade and classify pupils has been like that has been the primary responsibility of school principals since school principals came into being in the mid-1800s or so. Their primary task was to grade and classify pupils and attend to the discipline of the school and the orderly operation of the school, right?
And to keep them eligible for
and to keep
school
them
athletics
for football, right? Yeah, that is more of a recent thing, I guess. But yeah, the principal's basically claiming that they had the ability to do this, and the board is saying, no, you took it way too far. Your job is simply to determine whether or not the data that you have is sufficient to allow them to progress to the next grade. Like that's what we mean by classify pupils.
Mm-hmm.
And the principal is saying the clause in that provision that says that the principal has the ability to act in the best educational interests of the pupil. That seems to be what the principal is hanging on. So anyway, it's an interesting case. Don't need to spend a lot of time on it.
Yeah.
But it's just a little reminder for you folks out there. I would say that's a stretch.
It feels like a stretch. Yeah. Like I would love to ask that principal one question, which is if it's in the best interest of the students to change their grade, how many non-athletes' grades did you change to improve their grades? Because I think because if you're narrowing it just to student athletes, then you basically have to say that like it's in the student athlete's best interest to compete in athletics.
And it's not in anybody else's best interests for anything else.
Exactly. Right.
Wow. Yeah. So school administrators out there, be careful because that's a slippery slope. And I would exercise a little caution there.
For a lot of reasons.
Yeah. Obviously, we'll report back on that one if we get more information, if it goes anywhere.
I liked what you said about it's not in the legal system yet. because, almost every decision or action that a school takes isn't going to end up as a lawsuit, but there's so much consideration that goes into making sure schools are compliant that like reporting on stuff that doesn't become cases.
Yeah.
Typically a case is only when schools got it wrong. And I don't know the facts or the situation there or the law, but not changing athletes' grades seems like a good policy.
Exactly. What have you got?
Sure. So I saw some really interesting statistics about school board elections. So, in education law, school boards are so important because they basically are the ones making school policy. If it's not the state or the federal, they obviously have to act consistent with those mandates, but they have a lot of authority over kind of how schools are run, about hiring, managing budgets. All of these things come down to the school boards.
Not just hiring, but terminating too, right?
As we'll talk about a couple of times today, apparently. So there's some data from the 2022 election from Ballot Ready that found that 62% of all school board races were uncontested, meaning that there was only one candidate.
Wow.
Yeah, which is huge.
Yeah. So just like anybody wants to run for school board, and 62% of those people who ran didn't have anybody running against them.
Yeah, 3 out of 5, right? Which is really kind of staggering given how polarized school board elections can be, which is, a larger societal trend, but
ideological, right? Like how ideological boards have become.
Right. That's a good way to say it too. Yeah. So we've seen a lot of groups kind of emerging that are really running on those ideological platforms with like very single issues who don't necessarily seem perhaps interested in kind of the holistic picture of what it takes to run a school, but come in with a very specific kind of agenda. But even with that, like there's still only 60% of these are uncontested, which is wild. And really interestingly, so this isn't broken down by school board races, but for all of the races that Ballot Ready looked at, of the about 25,000 cases that were uncontested, of the uncontested races, 74%, the only candidate was from the Republican Party. And in 22%, the only candidate was from the Democratic Party.
Wow.
So there's a huge political split between who is running unopposed.
Wow.
Yeah, it's really interesting stuff. But it's just something to keep an eye on because school boards, and we kind of sometimes lose this, school boards are so important when it comes to education policy, education law. Some of the first thing you need to look at when you're thinking about like, is this legal, is look for the school board policy.
Yeah, you're right. We lose sight of that because we tend to just kind of focus on our own little communities. Like the important people in my life are my kid's teacher, maybe my kid's principal, guidance counselor. Like it's very, very hyper local.
Yeah. So go run for school board.
Yeah. Well, those are some interesting bell ringers. Let us move into today's topic, shall we?
Let's do it. What's on the lesson plan, Jamie?
Today, we are going to cover a case called the Sheldon Community School District Board of Directors versus Ronald Lundblad. So this is a case, it's an older case. This is, mid-1990s, but this case talks a lot about a teacher's behaviors, whether or not they were appropriate or inappropriate, and whether or not those behaviors provided the school system and ultimately the board, right, with enough evidence to terminate this teacher's contract.
Okay.
Yeah. So the big picture here is we've got a teacher who used some pretty intense humor and sarcasm in his classroom, in his high school classroom. And listen, like I know teachers who tried to infuse humor and levity and all of that stuff. And I think that that's great, right? It's really important to be dynamic and to have a sense of humor and to do all of that stuff. But, as many of us know, sarcasm can be very dangerous.
Right. Especially with the wrong audience, which if you're talking about middle school or high school kids, like when I was teaching, I did the same thing. Like I joked all the time. I tried to rein the sarcasm in a little bit just for exactly that reason. Like you don't know how your audience is going to interpret it, especially that younger audience.
Right. Everybody's different, right? And I'm the same way. Like when I first started out as a teacher, I guarantee you, I was, I was probably doing or saying things, nothing like extreme, but with age and wisdom and experience and whatever, like principal me wouldn't say some of the things that first year teacher me said. Like, again, I don't think it wasn't anything that would have gotten me fired or anything like that, but I became more cautious, right?
Right.
And I think at times overly cautious. I avoided saying things that probably didn't need to be avoided at times, but just to kind of, you know what, I'm not going to go there.
Right. Which is why it's so important to study cases like this that kind of like show us where those lines are so that we don't over self-censor, right? Like you said, I'm sure everything you were saying or going to say was going to be fine. And so much of this comes down to like, hey, maybe use common sense.
So many of these cases, though, that we're going to cover, like you look back at them 20 years later, or 10 years later, 5 years later, right? Whatever, you look back at them and you're like, why did they do that? Like, what were they thinking?
Yeah.
So in hindsight, you look at some of these and you're like, that doesn't make any sense. Why would somebody do that? But you know what? Things are complicated.
Right.
And the reason why people do things the way they do, you know, the reasons are complex. And one of the reasons why we're doing this podcast is to kind of give the actual examples of the things that got people into hot water so that, you know, if you're a school administrator and something similar comes up in your school, if you can think about some of these concrete examples, even though some of them might be pretty extreme, it gives you a little perspective.
Yeah.
And it allows you to check yourself or check one of your teachers or whatever, right?
Yep. It gives you a framework to kind of understand the implications.
The do's and don'ts.
Exactly. Yep.
Yeah.
So what did Lundblad get fired for?
Okay. So Lundblad was very, very sarcastic with his students. So Lundblad was a teacher in the school district. He started as a teacher in 1973. He was let go somewhere around 1992. The hearing that took place was in 1992. At that time, he was teaching 9th grade English and he was serving as the 9th grade football coach. The particular incident, they found out that there were a whole bunch of things that this guy did, but the particular incident that triggered this particular controversy involved a 14-year-old boy in the 9th grade English class. So they were asked to critique the movie Charlie. Have you seen the movie Charlie?
No.
I haven't either. And I was actually in 1992, I think I was in 9th grade. So, but that was, I don't remember seeing Charlie. I wasn't in his class. So the students were asked to critique the movie Charlie. And in an oral review of the film, the student said that he would rather be taken out into the parking lot and beaten to death than to have to watch that movie again. Oh, kids.
Okay, great. He's a 9th grader.
Yeah. So Lundblad, the teacher, gave the student's presentation a good grade. He got a good grade for it. But he wrote the following comment on the paper. Quote, "I'd be glad to take you out to the street and beat you to death. The way your face looks, I think somebody already has."
No.
Yes. And wait, context important here, right? Apparently that boy was suffering from an outbreak of teenage acne at the time.
Oh, no.
And he said, the way your face looks, I think somebody already has.
Oh my gosh, that is like devastating.
Yeah.
For a 9th grade, so like what, 9th grade, we're talking 15, 16-year-old boy.
Yeah, it's his first year in high school. Like, man. And, you know, the court report said that the student made light of the comment among his peers. Now, that doesn't surprise me one bit.
For sure.
Okay. Like, you know, he was just trying to brush it off, but he also testified, and his parents testified, that he was extremely self-conscious about his appearance, and he was hurt and embarrassed by the comment, which
for sure
makes perfect sense.
Right. Yeah. And yeah, I guess you can see what the teacher was trying to do here. Like the teacher is responding to something the student said, right? The student is basically saying that he doesn't value the assignment that the teacher gave him. And so like, you know, I can understand the teacher maybe getting defensive or like trying to justify it, or at least like matching the student where the student's coming from. But then like that knowing your audience is so important. It's so funny. This is an English class. So I was this student in high school. Yeah. So in my junior year English class, I loved my teacher, but like she did a couple things where it's like, you got to know your audience. So every week we had like you got to read something out loud and like share your work. And I wrote a poem called The Block-A-Day English Blues, which was all about how
terrible
blue
your class
I was. Yeah, having to like sit in her class for an hour and a half. And do you know what she did? She listened to it, was a good humor. She goes into her desk and pulls out a candy jar and gives everybody in the class a piece of candy except for me.
Oh, really?
Yeah. I thought it was hilarious. But like, she knew her audience, right? Like, everyone got candy. They knew I was kind of a joker. And so like, I feel for both parties here. Just recognizing though that like, maybe ragging on someone's appearance, especially a adolescent boy for his acne. Ooh, and also there's that threat of violence. Like, maybe don't threaten your kids.
Exactly. Regardless of what his motivation was, regardless of whether or not he was frustrated or upset by the boy's response. Like, those are just not things you say.
Right.
Find some other way to, you want to throw some humor in there. You want to throw some levity, like go the self-deprecating route, right? Like anyway. Apparently, this wasn't the first time that Lundblad had some run-ins.
I would be lying if I said I was surprised.
Exactly, especially if this guy has been doing this job since 1973. Okay?
Yep.
So earlier in that particular school year, the students apparently in the class were discussing Madonna, the pop star, and one of the students, who was the son of a local minister, said that Madonna was not so great and she was just selling sex, something that anybody, even he, could do. And the teacher responded and said something like, if that particular student tried to sell sex, he would go bankrupt.
Oh.
And furthermore, his brother would be his first encounter.
Oh, no.
Oh, wait, there's more.
Oh, no.
Apparently, he met with the parents in that particular situation. He acknowledged that his comments were inappropriate, and he assured his principal that it wouldn't happen again.
So he's on notice, right? Like,
this is not the first notice he was on. The personnel records revealed additional incidents with a similar sort of flavor. So in 86, he resigned as the 8th and 9th grade girls basketball coach after he referred to the girls as prima donna little B words.
Yeah, he said the word, but we're going to keep our clean rating. Yeah.
Our clean podcast rating. Yeah. And he offended his 8th grade track team with the observation that they were so bad, quote, they couldn't win the Special Olympics, unquote. Oh, yeah. So again, like, you're probably all listening to this right now and you're going, come on, man. Like, one of these incidents by itself is enough for some kind of action to be taken, right? Keep in mind context here. And one of the pieces of context is this was 30 years ago, right? And I'm not saying that it makes it okay 30 years ago, but things were a little different back then, right?
Sure.
Exactly.
Social norms change, all that.
There were complaints made, even though things were denied by Lundblad. One of the complaints was that he touched and looked at the girls in inappropriate ways and that his conversations contained sexual overtones that made the girls uncomfortable, things like that.
Well, given his comments to that minister's son, I'm not surprised.
Yeah. I mean, like, this is not out of left field, right?
Right.
Anyway, when the hearing came up about his termination, he did go on to admit that he once told a student who submitted a paper about teenage suicide that, quote, for extra credit, why don't you try it? Oh, that came out in the hearing. One of the things he said to the board to try to justify his actions was that his humor was a part of his teaching technique. He acknowledged that the use of sarcasm with impressionable adolescents could be a dangerous thing. So that was how he justified it. So what happened after that, Chris?
So the school fired him, right?
Really?
I'm shocked.
No kidding. There's some sarcasm for you, folks.
Oh. So the district, after this hearing, concludes that Lundblad has ceased being an effective role model and cannot be counted on to build self-esteem among his students, which they defined as an important district goal. But given what we've heard from his comments, I think that makes sense. It seems like that's a pretty justified conclusion, you would think.
Yeah.
But Lundblad apparently disagreed. Because
really?
Yeah. So this is one of those situations where local law is so important. So in Iowa at the time, you could basically appeal a school board's termination to an adjudicator. And then once the adjudicator made a decision, then you could take that to state court. So all of this is based on Iowa law, which is typically how most employment issues are handled. Most of those are state law issues.
Okay.
So, this is one of those situations where you really need to be aware of your local policies, your state policies. If you're part of a union, what's in the collective bargaining agreement, all of that stuff.
So this just as a little sort of context, in contrast to the case we talked about 2 weeks ago, which was a federal. It was based on the Constitution, right? This is a state case.
Yeah. So we kind of have two ends of the spectrum. where last week we talked about the U.S. Constitution, which is the supreme law of the land. Everything has to follow the Constitution. Now, this is a hyper-local decision by a local school board based on local state law. So
Got it.
Kind of got different ends of the spectrum, which is why in this one we end up in state court, and the Iowa Supreme Court is the ultimate kind of decider of this situation.
Okay.
So Lundblad appeals to the adjudicator, and he basically argues that the school board's decision didn't have enough evidence.
What?
Yeah, so basically he's saying, you didn't have enough of a reason to fire me. Your decision wasn't sufficiently justified.
Seriously?
It gets better. The adjudicator agrees. The adjudicator finds that...
Wait, somebody else said, oh yeah, I think you're right. There isn't enough.
Yeah. The adjudicator said that the school didn't have adequate support to support his termination.
Wow.
The adjudicator says something along the lines of, despite Lundblad's occasional deficiencies and his errors in judgment, you have to weigh that against kind of the length and the general success of his career, and that the kind of the preponderance of the evidence didn't support his termination.
Wow.
Yeah. So the school doesn't like this outcome, right?
Okay. Yeah.
So the school fires him. Lundblad appeals to the adjudicator. The adjudicator basically reverses the termination. School board now appeals that to the state district court.
Okay.
So the school board is arguing, no, we really did have enough evidence here. We've got all of these things that this teacher did. This is more than enough evidence to support our conclusion. And on appeal to the district court agrees, and they kind of highlight some inconsistencies in the adjudicator's opinion, basically saying that the adjudicator's conclusions were internally inconsistent because on one hand, they're saying that this behavior is unacceptable. But on the other hand, they're saying, well, sure, it's unacceptable, but it's not enough to give you just cause for his termination, which does seem a little contradictory, right?
Exactly. Yeah.
So that's how the district court comes out. But that wouldn't be the end of it because
he appealed.
He appeals.
Ah.
And the Iowa Supreme Court takes the case and they side with the school. So they say, yes, school, you had enough evidence to justify the termination of this employee.
Okay.
And the big issue here is whether or not there was just cause. So just cause is one of those legal terms of art that has very specific meaning in this context. So in Iowa at the time, tenured teachers' contract could not be terminated without just cause. So that's why this is such a big issue. If you don't have it, you can't fire him. If you do have it, you can fire him. And so defining just cause, the Iowa Supreme Court says that it is conduct which directly or indirectly, significantly and adversely affects what must be the ultimate goal of every school system, high quality education for the district's students. It relates to job performance, including leadership and role model effectiveness. It must include the concept that a school district is not married to mediocrity, but may dismiss personnel who are neither performing high quality work nor improving in performance. On the other hand, just cause cannot include reasons which are arbitrary, unfair, or generated out of some petty vendetta.
Well, that second piece seems pretty clear. You can't do it, vendetta, whatever, right?
Mm-hmm.
But all that first stuff, that's really subjective.
Right. Which is why when the Supreme Court is looking at this, they recognize that they have to give weight to the school board's factual findings, but they're not bound by them. And so this is a really interesting question of basically when you appeal it, do they get a fresh crack at it or do they have to basically follow what the lower court or the lower decision maker did? And here we've got a little bit of a balance. Yeah. So when the Supreme Court takes a crack at it, they don't redo the trial. They don't redo the hearing. They've just got the record in front of them and they have to give deference to the school board's factual findings. So the school board's conclusions about what happened, what the impacts were, that sort of stuff.
And so they're just basically looking to see if they had enough of that and if the district's ruling was justified.
Right.
Right.
And to be justified, they have to have a preponderance of the evidence, another one of those fun legal terms, which is essentially just like, does 51% of the evidence support the conclusion that the school board ended up with? I guess another way to say it would just, is it more likely than not that the school board had just cause based on the available evidence?
And the answer was they did.
Yes. So Lundblad argues that they didn't have just cause for a couple reasons. He says, one, this is a single incident. So talking about the acne comment, it's a single incident. That's not enough to justify my termination. In order to justify my termination, you had to go back years and years and years. And if those were so bad then, why didn't you do something about it then?
Really?
Yeah. And then he makes the ultimate argument that like, my behavior wasn't that egregious. There's been lots of other people who were fired for worse things. And this has all just been blown out of proportion. These parents are just disgruntled, and picking up the language of this court, he says, they just have a vendetta against me. Like they're just out to get me. Yeah. So that's his arguments, right?
Right. Well, I guess that didn't fly.
Nope, not so much. So looking at whether or not there was just cause here, the court finds that there was, because they say that school was justified in looking at this pattern, especially if the most recent incident was a pattern of kind of behavior, then you can use all of that evidence to support your finding of just cause. And this kind of shows why it's so important to keep good records and good documentation.
Exactly.
Because you're looking back 5, 10 years
Totally.
and creating this case, if you will. If you don't have that, or if it's just oral history, or someone remembers like, oh, didn't he say something a couple of years ago to that student?
Yeah.
If it's not written down, it becomes so much harder to prove, and then you can't use it as part of your evidence to kind of hit that evidentiary threshold.
Right. We hear so many stories about there may be this teacher or that teacher that we just can't let go, or whatever, right? And I know that these particular situations, every situation is unique, and, we don't always have the full story and all of that stuff. But to your point, like, you don't want to be able to not let a teacher go who needs to be let go just because you didn't do your due diligence and keep documentation about the issues that you were experiencing, right? You really need to familiarize yourself with state regulations, district policies, things like that. Some states are right to work states, so you can not renew a teacher's contract at the end of the year, and you don't have to have lots of reasons or documentation as long as it's not capricious or arbitrary or based on some sort of illegal, like, you can't fire somebody because they're pregnant. But you've got to familiarize yourself with state laws and regulations, because if you want to let a teacher go for legitimate reasons based on their performance or particular incidents or whatever, 9 times out of 10, if you've done your homework, if you have documented, if you have done everything that you need to do, maybe not 9 times out of 10, but a lot of the time, you'll have the ability, at least legally, you'll have the ability to do it. Now, we all know, like you said at the beginning, boards have a lot more influence than many people realize. For example, if a principal, in most places, if a principal wants to let a teacher go, that decision is not that principal's and that principal's alone. That principal has to make a recommendation to the superintendent or the board, and the board typically has the final say. And, who knows? There could be politics. It's this guy's nephew and whatever, like, who knows? But at least from a legal standpoint, you want to make sure that you're covered legally.
Right. Yeah. You got to document. And then you also have to cross your T's and dot your I's, because so many of these laws have very prescribed procedures. So it's not just, is your decision justified? It's also, did you get to the decision in the right way? Yeah. And so many of these cases hinge on whether or not you did it in the right way. So did you follow the proper steps? So did you give notice? Did you do the observations you were supposed to do? Did you give an opportunity to remediate the behavior? All of these different things are steps that can be written out into whatever due process is offered for these teachers. So it's not just, did you have just cause, or did you make a substantively correct decision? It's, did you follow the right procedure? And what's really interesting about Lundblad's case is he doesn't make any procedural argument. He doesn't argue that the school did anything inappropriately. He just says you didn't have enough to justify your ultimate conclusion, which is actually pretty unique. Most of these come out on like, you didn't follow the right procedure. You didn't get notice at the right time. And if you mess up the procedure, like, you're stuck because the decision's going to be overturned, because decision that is based on an improper process is suspect.
Yeah, that's due process, right?
Right. Yeah, and we'll spend a lot of time talking about due process and what that means in both the employment context and the student context as well.
Sure.
But that's another one of those legal terms of art. And it's one of the things that I actually find is the hardest for non-attorneys to kind of grapple with, this idea that we need to get to a decision in the right way rather than just jumping to what is the right decision.
Yeah.
And it's something that, like, a case like this, the evidentiary burden is a piece of that. Like, basically, sure, this might have been the right decision,
Right.
but can you justify it? Do you have enough evidence? Did you go through the hearing? Did you produce the evidence? Do you have the
Right.
documentation? Basically, can you back it all up?
Yeah. And it's these kinds of due process cases that have, over the last 50 plus years, have really helped districts define those processes and those procedures to ensure that if there's going to be a legal hangup, it's not going to be because of that.
Right.
It's not going to be because of, we didn't follow the right process. Here is our process. If you want to let somebody go, you make sure that you have this, this, and this.
Right. Yeah.
Right.
And it's so important to know that stuff because apparently in Lundblad's case, they did it right because he only could basically challenge whether or not they had just cause.
Right. And listen, you mentioned it last week, and we'll probably say it over and over and over again on this podcast, but the law is so fact specific. So if the facts of this case, if any of them had kind of changed, who knows what the outcome would have been? Like, for example, if Lundblad didn't have such a track record of these kinds of comments, and this was sort of a one-off thing, and the school let him go, the outcome could be potentially very different. Now, maybe the outcome would have been very different 30 years ago, but maybe if the exact same thing happened now and it was a one-off, because again, societal norms, things change, and those kinds of things influence the system. But in this particular case, just cause was there.
Yeah, and I think it depends on which of his single statements you take in isolation, because today I could see...
Yeah, there's a few of them there that would cause some problems. Well, that is really interesting. I think that's probably a good spot to wrap this up. And just don't forget, folks, document everything, remind teachers, if you're listening to this, you got to be real careful with that sarcasm. Well, not just teachers, like anybody, right? Teachers, coaches, principals, assistant principals. If you're working with kids, you've got to be careful with that sarcasm and with that humor. In no way are we advocating against humor. Humor is great.
If I couldn't attempt to be funny when teaching, I don't know what I would do.
Exactly, right? Like, if you can't laugh, what have you got? So just keep that in mind. Be careful. Do your due diligence. Document. Follow the procedures. Know your procedures.
Yes.
And you will probably not find yourself in a courtroom. All right. Let's hit the homework now. Chris, what do we got?
Sure. So your homework, you can find Chalk and Gavel wherever you find your podcasts. Please subscribe, like, review us. You can check out our upcoming episodes at our website, chalkandgavel.com. If you have any questions, comments, or if there's any topics or cases or anything you want us to cover, there's a form up there on the website, or you can engage with us on social media at Chalk and Gavel. We'd love to hear from you and keep the conversation going. Also on our website, we have a flyer for you if you want to print that out and put that up in your local coffee shop, in your school, wherever you might want to spread the word about Chalk and Gavel. Tell a friend, tell a classmate, tell your students, whoever it might be, tell your staff. We'd love for you all to spread the word and to get the word out there about Chalk and Gavel.
All right, and that does it for episode number 2 of Chalk and Gavel. Thank you so much for listening. I'm Jamie Cudlitz.
I'm Chris Thomas.
Join us in 2 weeks when we continue to explore how the courtroom is connected to the classroom with a fun case involving a cussing cheerleader. See you then.